I'm gonna be back just in case like randomly everyone gets here in like the next couple of seconds. I'm gonna use the bathroom and grab some water and a snack. So I'll turn my camera on when I'm back and ready to judge.
Can you guys hear me?
Yep.
Yep.
Okay. Can you see me too? Sorry, wait.
Yes.
Okay, my mic and camera have been glitching out, so just making sure. I'm sorry if it does go off. I will try to fix it, but there's a possibility.
Is on.
All right, have we flipped for sides yet?
We have not.
Cool. Does anybody know who the higher seed is in this round or no?
I don't know.
That's fine. Who wants to call the flip?
It doesn't matter to me, honestly. Either way.
Either is fine with me too.
Cool. How about we have how about Chris? How about you just call? Do you want heads or tails?
Tails, please.
Cool. It is tails. What side would you like?
I would prefer the ass.
Okay.
All right. So Diablo Valley is F. Sac State is Neg. Cool.
Just give me 1 second. I'll set up the speech drop. Okay. Give me 1 second to upload my speech. Sorry, having some technical stuff. Okay, does everybody see that okay? No, went in. Okay. Great, looks good. Everyone can see that okay and stuff?
Yes, I'm good.
Cool. All right. Is anybody not ready? Awesome. Okay. Harms. Harms. U visas are a means for victims of abuse to immigrate to the United States in exchange for aiding law enforcement. Inherency, the existing limits on U visas in the SQO have resulted in a massive backlog and long waits for victims. USCIS, April 2020. At the end of 2019, there were nearly 152,000 pending principal petitions and nearly 104,000 pending petitions for family members. Because the number of individuals issued principal UN visas in any fiscal year cannot exceed 10,000, the wait time for a principal petition to receive a final decision is currently 5 to 10 years. If filing trends continue, the pending queue and associated processing times will continue to grow significantly. Plan, the United States federal government should amend the U visa by A, eliminating numerical restrictions, law enforcement certification restrictions, and helpfulness restrictions for immigrants reporting intimate partner violence. B, remove the 3-year waiting period and requirement to submit an application to grant permanent resident status immediately for all applicants. Solvency, eliminating the caps is key. Delays due to the cap prolong the suffering of victims and are unique to U visas. Settlage 2016. Only 10,000 U visas can be issued in a year. This cap impacts the safety of domestic violence victims. These battered immigrants are left in a perilous situation. They've reported their abuse but have years to wait for lawful status and the federal benefits that might help them extricate themselves from their abusive situations. The cap is yet another way that U visa is unique as a form of immigration relief for battered immigrants. There is no cap on the number of battered spouse, whether VA, WA, self-petitions, or orders of cancellation of removal that can be granted in a given year. Removing the law enforcement cooperation and helpfulness requirements eliminates the dual intent status and makes the U visa exclusively a path to LPR status. Settlage 2016. Battered immigrants who are eligible only for U visa relief are the only battered immigrants required to cooperate with law enforcement in investigation or prosecution of their abuse. U.S. immigration laws are complicit in making immigrants vulnerable to abuse. Amending the LEC requirement for waiver of law enforcement cooperation requirement in the case of trauma, increased training for law enforcement, or changes in state law do not go far enough. Requiring law enforcement cooperation is not reasonable. Disparity can be remedied by eliminating the LEC requirement entirely. Unless eliminating the LEC requirement includes eliminating the helpfulness requirement, battered immigrants will still face significant barriers to obtaining protection. The underlying requirement of cooperation with law enforcement needs to be recognized as an inappropriate requirement for domestic violence victims and should be abolished. Advantage 1, interpersonal violence. Latinas are uniquely and disproportionately victims of interpersonal violence. They experience it more frequently and more severely than their white counterparts and have worse mental health outcomes. Immigration status and barriers to reporting specific to law enforcement are limiting factors in the SQO that must be resolved. Regerum et al. 2019. The National Intimate Partner and Sexual Violence Survey indicates that 37.1% of Latinas compared to 34.6% of white women reported that they had been the victim of physical violence and are stalking by an intimate partner in their lifetime. The prevalence of IPV for Latinas in the past 5 years, 20.1% compared to 14.5% for non-Latinas. Latina couples have a higher rate of incidence of IPV compared to non-Latina white couples and at a higher rate of reoccurrence. Latina IPV victims suffer from more serious forms of IPV and more health consequences. Latinas are more likely to die from homicide. Latinas have more worse mental health outcomes, mental health functioning, emotional functioning, vitality, and suicidal ideation. Latinas tend to stay longer in abusive relationships before seeking assistance. Immigration status is one of the issues of power and dominance that comes to play in IPV. The undocumented status of some Latinas may further exacerbate the situation. One study found high rates of abuse, including physical, sexual, and psychological abuse among undocumented women. Factors might make it more challenging for survivors in these communities to seek or access help. Latinas experience immigration status barriers along with difficulty in accessing and utilizing services. Indeed, Latinas who are undocumented were less likely to seek help compared to Latinas who are permanent residents or citizens, even though they were not more likely to experience IPV. Immigrant communities might feel the need to protect members of their community from potential negative treatment by law enforcement, and hence survivors are reluctant to report IPV. U visas solve in 3 ways. A, they improve emotional well-being. Regerum et al. 2019. Women experience improved emotional well-being with the receipt of the U visa. It was a transformative and life-changing experience for them. Natalia, a service provider, expressed they become real human beings. Before, they always felt like they were in chains. They did not feel free. Rena articulated, when my U visa came, I cried with happiness. My heart, for the first time in my life, I had something that was really mine and has given me life. B, they provide economic stability. Regerum et al. 2019. The women experience improved economic stability. Maria, I make enough money. I can sustain myself, not like before. Before, no, I was always left without money. It didn't cover for food, a lot of things. Without a U visa, women's economic well-being improved. The visa serves us well in that aspect, yes, because we can look in any place to make more money. C, Adelante, hope for the future. Regerum et al. 2019. Hope for the future, Adelante. Women made plans to get ahead and improve both their lives and those of their children. The women were excited that they could provide better for their families, offered them better opportunities to succeed in life. The women stated that providing their children with legal papers allowed them better access to a good education, student scholarships, jobs, and a more promising future. Additionally, the women felt that they could now have better access to services for their children, such as daycare and medical care. In addition to providing for their family, women were very keen on their own personal growth. They were keen on improving their language skills and enrolling in English as a second language classes and GED classes. Indeed, several women made plans to go back to school to get a degree or even complete their GED. Some women wanted to realize their dream of opening their own restaurant or business. Framing. Rejecting intimate partner violence in favor of low probability impact is an abdication of responsibility and allows for more women to experience trauma in the future. Stratton, 89. This attitude is an abdication of responsibility. There is no acceptable level of death, no acceptable level of humiliation, and no acceptable level of degradation. I am sick of hearing men say rape is not their problem. Women who survive an assault experience a problem that will transform their lives. What do many men say? Oh, I'm sympathetic, but I've got to put my energies into stopping nuclear war or environmental destruction. The same male patterns of violence involved in power, control, and humiliation in international conflict are involved in the violation, degradation, and domination of individual women by individual men. Addressing intimate partner violence outweighs and is a prerequisite to the prevention of war, Duncan 07. The number of women murdered by their intimate partners in the last 11 years is equal to the number of U.S. soldiers killed in the Vietnam War. Just as war causes many deaths, so too does violence in the home. In addition, domestic violence has a far-reaching impact, the future generation of society. Adolescents who have grown up in violent homes are at risk of perpetuating the abusive relationships. They are more likely to attempt suicide, abuse drugs and alcohol, run away from home, and commit sexual assault crimes. In fact, a child's exposure to the father abusing the mother is the strongest factor for transmitting violent behavior from one generation to the next. Domestic violence runs the risk of being overlooked, especially amidst more outwardly demanding social and political issues such as war and terrorism. However, violence in the home must be addressed before a culture of nonviolence can be achieved. I'm open for cross-ex.
Perfect. I'm just going to set my timer.
Okay.
And start now. So can you kind of explain in brief what exactly your plan is removing?
Sure. So our plan removes a number of restrictions. It gets rid of the 10,000 cap on the visas, on U visas. It eliminates the 4th eligibility requirement for the visa application pertaining to certification of helpfulness by law enforcement, and it eliminates the 3-year waiting period required to receive permanent residence and confers it immediately upon a successful application.
Okay, so is the 10,000 one the numerical restrictions that you explained?
Yes, the 10,000 cap is the numerical restriction on the cap of the number of visas. Yeah.
Okay. Does it say in specific in your plan text that it's 10,000 that you're removing?
It says specifically eliminating numerical restrictions in the text of the plan.
Okay,
the numerical restriction in question is 10,000. So.
Okay, so where does it say that it's 10,000 in your cards?
I believe it says it in the Settlage 2016 card. Only 10,000 new visas can be issued in a year. Under solvency, if you want to look there.
Okay. What card did you say? Sorry.
The Settlage 2016 card, the first card, the first piece of evidence under solvency.
Okay, perfect. And then how does your plan solve for like the long backlog?
By eliminating the cap, it allows more applications to be processed, and therefore more applications to be passed, as well as removing the law enforcement certification restriction allows more applications to be passed, and limiting the 3-year waiting period also allows more to be passed or to be approved.
Okay, you don't think that making more restriction or less restrictions would just make the period longer?
No, if there's less restrictions, that means there's less things to check for, so It should be faster.
So how are like Latinas, because you talk about that a lot, uniquely likely to experience violence if this isn't passed?
Because the visas they've demonstrated that getting a U visa can help women extricate themselves from dangerous situations, and as demonstrated by the Regime et al. 2019, Latinas are in the status quo uniquely targets of that violence, especially and the women are less likely to seek help because of their immigrant status.
So basically, your main impact is that women face violence. Is that right? And
their main impact is domestic violence. That is correct.
Domestic violence. Okay. I think there's only 3 seconds left, so I'm just going to cut my time right there, and then I'm going to use all my prep time in my last speech. So I'm just going to submit my document right now. Sorry. Let me know when everyone has it up, and I will start my time whenever you're ready. And then I'm just going to be addressing off case and then on. Perfect. Everyone good? So silence good? Okay. Then I'm going to be starting in 3, 2, 1. Statute spec interpretation. The affirmative should specify which statutes are being removed, by whom, and how many. Immigration policy is misunderstood and precision is necessary for a negative ground. Vague plans don't prove a propensity to solve. Pass Law 94. U.S. immigration policy are frequently misunderstood in debates. Immigration policy needs to be viewed as 3 fundamentally different sets of rules. There are those that govern legal immigration, those that govern humanitarian admissions, and those that govern illegal entry. The distinction is important. Each set of rules is governed by the different legislation, involves different networks of bureaucracies, is guided by different goals. As immigrant entering as refugees, as legal immigrants, and as illegal immigrants differ in different ways, ignored in policy debates. Violation. The act doesn't specify which lines of statute are being removed in the plan text. Reasons prefer plan and vacuum. The plan is the only stable locus of contention in the debate and therefore should be elevated in vacuum. In the plan, a vacuum is vague, you vote neg. Generic plans are bad for education and aren't real world. Their act wouldn't make it past the clerk's desk in the policy process. Predictability. Failure to specify the statute makes the act a moving target and unpredictable. The 1A-R can always pivot, which destroys the 1A-C. This is uniquely unfair in the format because it shifts the debate to when they have 9 total minutes and extra speech to clarify, destroying our ability to test topicality or solvency. Cross-X does not check back. Limits. Not specifying the statutory restrictions in the plan text explodes limits as it becomes impossible to determine which statute is being removed specifically. It justifies FXT. As the action the AF advocates for might not be on restriction on legal immigration, but may lead to less restricted immigration, FXT is an independent voter. Grounds. The AF skews our ground. Vague plans make it impossible to generate DA links. Comparative counterplans or test solvency. Just having immigration reform without specifying what that is makes it impossible to evaluate whether or not the AF is topical. This destroys every off-case negative argument. On to the K. Thesis. Biopolitics refers to the techniques and discourses used by government agents over populations to reproduce the fear necessary to exert power over against society. This manifests itself in biopower, which uses mechanisms of control over the body to reduce individuals as docile bodies that can be controlled, disciplined, and eventually disposed of in the name of peace and social life. Catastrophe 17. Foucault's analysis of governmentality allows a better understanding of the relationship between fear and modern power. Fear is actually what the government agent of the state reproduces over time to establish the control of social body through preservation of life. The government uses fear to govern the population and to wage war in the name of life necessity. Fear is what must be reproduced to establish control through a series of governmentalized techniques. Among those forms of governing, biopolitics can be characterized as a political technique of governmentality for controlling and governing citizens. The concept of biopower signifies the power of abstract force realized through practices associated with the body. The human life is biopolitical dimension. Biopower is exercised, recreate individuals as docile bodies, controlled by political reasoning. Abdomen also knows that governmentality produces a bare life, in which species as simple body becomes what is at stake in society's political strategies. Framework. Disrupting the biopolitical apparatus requires the objector to take on the role of specific intellectual to negotiate local sites of struggle within the institution itself, reshaping the conscience of individuals and promoting change in the real world. You're about to uncover how we as debaters are produced institutionally. Whitman 06. Disrupting the technology of biopolitics is a difficult task, but not an impossible one. Acting within institutional boundaries is quite possible. The task of a specific individual is to respond to the local contingent sites of struggle in the context of global. To uncover how we are produced institutionally, human beings can defend against some forms of power. As an educator, the importance of biopolitics in education is that the regulation of the social accounts for a lack of analytical critique. Pedology, empathy has been substituted for the analytical. Producing morally tolerable students, right-thinking individuals has become a staple in transformative pedology. We need to regard them as initial steps. Social change takes place through a change of heart, an altering of effective conscience of the individual to create compassionate culture. Link. The U.S. visa process subjects immigrants to a biopolitical apparatus in the forms of fingerprints and tracking. Rosenberg 13. When you apply for a visa to visit the United States, a permanent state of consular officer will require your fingerprints and photo. On arrival into the United States, biometrics will once again be collected so that the identity of the visa holder can be confirmed. You'll also be asked to provide these data when leaving the country in order that the state can keep up track of who is entering and leaving the country. Their main aim is to work towards a safer and more secure America, which is resilient against terrorism and other potential threats. The use of biometric data is a widespread phenomenon undermining the political judicial status not only of people who are influenced by it, but all citizens. The problem is the balance of power. Citizens become vulnerable and prone to manipulation when the states collect sensitive information about their health, behavior, etc. The impact is endless war. Biopower exercises fear to wage war and draw lines between the others as enemies and those who are saving. Catastrophe 17. War in modern society has now become the regime of exercising biopower politically, particularly on the war of terror as a form of rule aimed not only at controlling the population, but producing and reproducing all aspects of social life in order to preserve life from the disasters and atrocities of war. Liberal regimes have to conduct war-on-war campaigns by deploying strategies that must not only target the lives of the enemies, but also the lives of the population in need of preservation and protection. In this context, the current war on terror is no different from all other liberal wars being waged on life, but all on behalf of life itself. They use the fear of terror as the defense of vitality. The government exercises the use of governmentality technique in which the biopolitical forces play an integral role in the state strategies that make the war war and terror possible. The alternative is to resist sovereign power through the refusal to produce distinctions. All political binaries are protected upon the distinction between Zo and Bios. By refusing to draw lines, we can contest the sovereign ban through contestation at the level meaning an exception. Against 4. One potential form of resistance to sovereign power consists of refusal to draw lines between Zo and Bios, inside and outside, human and inhuman. We're suggesting that it's only through a refusal to draw any lines, and indeed nothing else will do, that the sovereign power as a form of violence can be contested and properly political power relation can be reinstated. We can escape sovereign power and reinstate a form of power relation by contesting its assumption for the right to draw lines. That is, by contesting the sovereign ban. To move outside it, we need to not only contest its right to draw lines in particular places, but also resist the call to draw any lines of the sort of sovereign power demands. Strategies that address where lines are drawn, undoubtedly crucially important and often seem the only possibility for resistance. Although they contest the violence of sovereign power's drawing of line, they risk their own violent relation and demanding that the line be drawn differently. In both cases, the drawing of the line represents a foreclosure of possibility and a denial of the properly political power relation. The metaphysics of presence that sovereign power's founding and foundational's drawing of a line proposes can be challenged examining the relationship between time and politics. The possibility of resistance lies in taking time and making time for politics. Miscounting and a refusal of and resistance to the grammar of sovereign power's drawing of lines between which counts, Bios, and which does not, Zo, is the actual refusal to play sovereign power's language game and follow the rules of counting. Her answer is a form of communitas that's non-conventional, non-statistic, non-sovereign, and non-biopolitical. Their plan really did not have any indication of what they're actually removing. Like I said, the numerical restrictions is super vague, and it makes it hard for me to actually have come up with an argument against that. Their plan is obviously just creating a longer backlog. We can help out these women of these Latinas and help them from the violence by advocating for this alternative plan. We're helping them escape this violence while also not being holding these immigrants to the biopower of U.S. government. Thank you so much. And then I am open for call 6 whenever you're ready.
Okay, great. So I have a couple of questions. First off, how are you doing today?
I'm doing good, thank you.
Yeah, that's great. So in the alt that you proposed, sorry, could you specify what your alt was again?
Yeah, definitely. It's basically refusing to draw any boundaries.
Okay. Does the state still exist after the alt?
Yes.
Okay, so then how does it solve for the problem?
That's a good question. So basically it solves the problem because biopolitics is a really major issue, especially with immigrants that they're being forced to be monitored and tracked without their consent, and they don't really know about it. So basically it would help these immigrants not be formed biopolitics.
Okay, but the state still exists, which is the source of biopolitics, correct?
Yes, but it's still like harmful to these immigrants to be forcing them into the biopolitical forces.
Okay, so how exactly do U visas, which already exist in the present and are being used, increase biopower if we're removing restrictions from them in our plan?
So it directly increases biopower because you're removing the more U visas that people can come in. When you apply for a U visa, you're directly getting your fingerprints and ID, and you're being subjected to the tracking. So that's how it links to the U visas. And the more U visas that are created, the more U visas, or the more biopower, the more these citizens are subject to biopower, sorry.
Okay. And who is the actor for the alt?
Who is the actor for the alt? I'm actually not sure on that. I've never... The actor on the alt the actor for the alt is really just everyone, the government, in particular, I believe.
Okay, the government in particular.
Yeah.
And so if the government is the actor, how is that not a continuation of biopower?
Because they're not the ones that are able to, the government as of right now can determine who's a good immigrant and a bad immigrant. So if the government takes away that, that form of biopower, then they wouldn't be the controlling factors. But
they would still exist. So as you said in the alt, so how can they stop existing as the alt? Like the alt is to remove all restrictions. So how can the state remove itself? It's the actor.
It's not removing. You're saying how can the government remove itself?
Yeah, which is the alt, correct? That it's essentially removing, in order for
Saying
the
removing
access to impacts,
boundaries.
that has to resolve for biopower, so the state has to stop being a significant character in the conflict.
Oh, that's fine.
Okay, I'm going to take a minute of prep if that's okay with everybody, and then I'll hop in. Okay, it's 1 minute used. So I'm going to upload this real quick. Hold on 1 second. Okay, can everybody see the speech okay? Good. Okay, I'm gonna, so if is anybody not ready? Okay, overview. First, we'll address the topicality, then critique, and then our case, and then theirs. First, immigration reform. Well, we meet. The AF amends the U.S. codes 1184 and 1255. If my opponent had in cross-ex asked me to specify which statutes were being used, I could have easily done so. They instead asked what restrictions were being used. So we easily meet their definition of topicality. Counterinterpretation. Immigration reform is a term for changes to laws governing immigrants and immigration. Gamboa 2018. Immigration term is a catch-all term for changes or attempts to change laws governing immigrants and immigration. We meet the counterinterp. We change the laws governing immigrants pertaining to U visas. Reasons to prefer. 1. Field context. Preferred interpretations rooted in the practical application of the resolution. They are most real world and still allow for policy-based analysis. A. The mandate of AF has been discussed directly in the context of Congress debating immigration reform. Raimi 2018. As Congress debates immigration reform, it should seriously consider eliminating the U visa cap. B. The most recent congressional service on report directly addresses U visas. Congressional Service, October 20. U non-immigrant status available to certain non-citizen victims of crime, and the U status also provides the path to permanent residency. See, it's sufficient. Immigration is a process. As long as we defend that the people our AF applies to are granted entry rights to the U.S. and a path to LPR, so that it should be unable to generate sufficient links to any legitimate disad. Johnson 2019. Legal immigration is a process whereby foreign nationals may apply for and obtain permission to enter the country, can take the form of visas or establish permanent border status. 2. Default to reasonability. Competing interpretation means that even if you thought the AF was 100% topical off the 1A3, we would end up voting us down based on the tiniest of drops. That is sophistry and bad for education and fairness. If you think the AF is reasonably probable, that is sufficient to affirm. And again, I'd like to remind you, we easily meet their definition of specifying statutes. If my opponent had asked me, I would have answered. K. Theory. Interpretation. The negative may not read a counterproposal which critiques the form of government, economic system, or need for further study. From the NFALD rules, access November 2020, access 2021. Sorry. The negative may also present one competitive counterproposal specific to the affirmative problem area and not dealing with the form of government, economic system, or need for further study. Violation. They read a biopower critique indicting the form of government. Standards. 1. Rules. A. The rule is clearly constrained the negative from reading this kind of position. Both teams have access to the rules ahead of time, which means it's unreasonable for the AF to have to prepare answers against strategies that violate those rules. B. The rules also say all negative proposals should be held to the same standard of solvency as the affirmative, which means if you don't understand the mechanism of how the alt solves for the harm for the AF, or the K, you vote AF on presumption. And again, I'd like to remind you the actor they specified was the state, and I don't understand how that solves for that alt. 2. Specificity. Biopower links to literally everything. This forces a generic debate where rather than actually engaging with the substance of the AF, they just indict the government or visas generically. That means absent a specific indict of U visas, you just buy the perm and vote AF. Voters, a priori. NFL rules say they can't do this. Following to the rules is key to fairness in education. It comes before T because reading this K undermines our ability to answer other sheets. A2, critique. Answers, critique. 1. Prefer our framework. Extend Stratton 89 and Duncan 07. It is paramount that you forefront the discussion of battered women to prevent that violence from being ignored in this space. 2. Real talk. Any critique that is incompatible with advocating for women to stop being subservient to the state and their abusers by altering their material conditions is not even worth considering and links to recreations of violence. 3. Perm. Just do the affirmative in all non-competitive parts of the alt. The only competitive part is to vote neg, which they didn't read solvency for. A. Double bind. Either the alt can overcome the exception of the AF, or it can't resolve the links to this code. That is critical because U visas already exist. We just make them more accessible. 4. Link turn. Foucault's conception of biopower and discipline and punishment is that knowledge is and exerts power and control, i.e. we are disciplined into having knowledge of complex laws, otherwise we will be thrown in the cell. The AF straight turns this by decreasing the biopolitical control exerted by the bureaucracy of U visas. 5. Alt doesn't solve. There is zero explanation for the alt specifically resolving the harms of the affirmative. Telling women to just get used to the suffering isn't solvency. And again, the actor they specify that's trying to solve this is also the one causing the problem they are critiquing. 6. AF outweighs. Commensurability. No articulation on how the specific mandates of the affirmative generate links to the critique or are otherwise incompatible with the alt. Means any risk of affirmative solvency makes the AF a disadd to the critique. 7. The state being bad in the status quo is the entire point of the affirmative. We make a demand that they cede power to battered immigrant women. Coker 01. Mandatory policies make irrelevant battered women preferences, limit the control of individual women. Policies further state control of women, particularly women who are marginalized by immigrant status or those whom state actors perceive to be deviant. Dilemma of making domestic violence a public responsibility in the context of classes, races, and classes public systems. Arrest in domestic violence cases involve disproportionately high numbers of low-income men, African-American men, and Latino men. Despite evidence of disproportionate effects, negative effects of mandatory policy on some poor women, particularly on poor women of color, may be significant. Rising of the rising tide carries all boats. Law and policy that is based on the experience of poor women, especially poor women of color, likely to result in reforms that benefit all battered women. 8. Disadd to the alt. The root cause is not reverse cause. Absent an explanation of the explicit mechanism for how they solve for the AF, you weigh the impacts of the AF as a disadd to the alt. The state still exists post-alt. 9. No, as they specified in cross-ex. 9. No link for their actor. Their actor is the state. How can the state solve for intrinsic problems of the state that they're critiquing in Foucault's biopower? Second, I'd like you to extend almost the entirety of my first speech. Overview. Vote AF to reduce limits on immigrants escaping emotional and physical abuse, which is cyclical in nature and locks in system oppressions. 1. Extend USCIS 2020 existing caps of created barrier. 2. Extend both solvency cards by settlage AF solves by eliminating core barriers in the caps and certification process. Plan doesn't preclude working with law enforcement, but it gives women agency. 3. Extend the advantage that is all the Registrar et al. 2019. It tells you 2 things. A. Latinos are uniquely being affected by horrific violence. B. The plan solves by improving well-being, economic stability, and creates hope for the future. 4. Extend our framework, Stratton and Duncan. We have an ethical obligation to face the violence these immigrants face. Okay. That's my time.
Okay, I'm going to take my 4 full minutes to prep. Sorry. Okay, I'm going to be submitting mine into the speech drop right now. Sorry, my computer is acting slow. My Wi-Fi. Okay, it should be up now. Let me know if you can see it.
I have it.
Okay, awesome. If everyone's ready, I will start my 6 minutes. I'm just gonna be addressing K and then some on case.
Tim, are you ready?
And then K. Is everyone ready?
1 second. Is Tim, are you ready? Okay, great.
Okay, awesome. Where did it go? Okay, I'm going to be starting in 3, 2, 1. So first off, their plan never specifically states the actual numerical restrictions, which means that they were being non-specific, which means we win that argument. You'll be voting negative on your ballot. The affirmatives hard linking to this position mean that 1AC is expanding the biopolitical apparatus of the sovereign. They've conceded that this uniquely constructs the techniques of control that are essential to how the state exercises biopower over populations. The affirmative draws a line between who is deemed worthy of living and performing the citizen. Your ballot is key to understand how this institutionalizes the immigrant into sovereign power. These techniques of governmentality physically and discursively expand the sovereign's ability to track, identify, and organize populations into groups that can be disposed of in names of peace. You can read this as an independent case turn and a reason to reject the AV with or without the alternative. Endless war means death to our enemies and a reason to reject the perm. The 1AC uniquely contributes to the state war machine. The biometric regulation placed on permissible populations is a starting point for how the state constructs who is friend and by proxy who is enemy. This means that the 1AC is the starting point for biopower fueled wars exercised in the name of saving those deemed worthy. The war of terror is responsible for more deaths and destruction in the third world than COVID. The logic of the 1AC leads to trillions of dollars for drones and bombs in the name of peace and protecting the citizenry. But this is all temporary construction, as the war machine will be pointed out just as easily once we are deemed the threat. This is the entire thesis of the 1AC. The 1AC has zero solvency for any of the hypothetical constructed happy world. Perm severance. Perm is a severance. This is a method debate. Interpretation that affirmative must defend stable and unconditional mechanisms for enforcement as their methodology from the 1AC through the 1AR. There is sever out the unconditional enforcement of the biopolitical techniques of the government of the 1AC. You can write this as a severing out the reps on your flow. This debate. So this shifts the debate to the last two speeches. Standards moving target allows them to spike out their offense by removing parts of the plan that link. It is the same of the affirmative conditionality ground. It kills our critique ground because they can remove parts of the plan to make everything not competitive meets the 1NC. Our ability to respond is limited by the extra affirmative speech. Time skew between the 1NR and 2AR is not the answer. I can't respond to anything after the speech. You must protect me on your flow. This is a uniquely key in the NFALD format. And is an internal link to fairness in debate. Fairness severance is a voter for fairness because the negative losses access to stable ground. Without stable ground, all negative counter proposals and disadvantages become null and void if the 2AR puts any defense on them. This collapses the ability for negatives to compete against affirmatives in NFALD debate. This position is a question of access in the discourse of the round, not a link to the K. We aren't drawing any lines. We're asking the AF to defend their appeasal. And then, that's just a repeat. So I would just like to say that the K is very valid in this circumstance. They said that biopower links to everything, and that is just really not the case. It is clear that their case triggers biopower extremely, and the alt does solve for the problems that it's advocating for. It's clear that the more people we have come in through the UV visa program, the more people are going to be subject to this biopower. So of course, it's never going to be completely done, but why would we subject more and more people to a form of biopower? And the only way biopower will be completed actually is if the alternative, if there are no boundaries for immigration restrictions. Like I said, there will be no way this will happen without the alt. Next, they said that we can only present one counter plan. I did not read another counter plan. I just read my alternative. We are not completely indicting the government like my opponent says. We're actually just, like I said, trying to remove the boundaries that the government sets. It's not like we're going to completely wipe out the state and not allow them to have function anymore. We're just asking for them to have less restrictions in terms of immigration. I mean, no restrictions in terms of immigration, because it's unfair. And they say that these women, that my alt is completely ignoring these women, and that's completely not the case. We're actually helping these women along by solving all of the issues that they're indicating. We're solving it because we're allowing these people to come into the United States and leave as they please. So we're allowing these people to escape from the violence that the 1AC suggests. And there's not even a high, really a link to, in the 1AC, there's not really a link to the violence and in their plan anyways. But if there is a link, we do solve that. We solve, anyways, you will be voting for the negative today because really it's the best ground for everyone. We're allowing these people to come in and have better lives and come and go as they please without being subjected to biopower. Because like I said, biopower just creates a cycle of endless war and allows these people to be manipulated. It's unfair that they're saying we can't debate biopower just because they may not understand it or may not, or it disagrees with their plan. So that is why you'll be voting for the negative today. Thank you.
Okay, I have 3 minutes of prep time left, if my math is correct, so I will take that now. Okay, that should be my prep time. Give me 1 second to upload this last speech. I want to make sure everyone can see that okay. Sorry to ask this every time, but I'm having some technical issues with it. Does everybody see it okay? Cool. All right. Is anybody not ready? Okay, Judge, today this is an incredibly straightforward vote. You'll be voting AF because their K is a violation of the rules of NFL ALD debate, which they cold conceded in their last speech. They did not contest the idea that they were violating the rules of the debate, simply said they were right to do so. This is an a priori voting issue. We can't even have a debate. We can't prep. We can't do anything if our opponents do not play by the rules of the debate. If you don't want to vote on this conceded rule violation, you can vote on our challenge to the K, that our framework prioritizes women materially suffering now, as opposed to an abstract notion of biopower, which their alt does not solve for. Their alt does not solve for. They specified in cross-examination that their actor was the state, the source of biopower in Foucault's theory, the actual actor that engages and wields biopower against the people that the alt hopes to solve. I'd like to address their case. We did not concede their critique. We said you should prefer our framework because it prioritizes the material conditions of actual women in the status quo. If my opponent was plowing this debate rather than just reading cards, they would have seen that we did not concede that. The alt can't solve. It just makes no sense. They specified in cross-ex that the state was the actor, the specific entity being decried by the K and Foucault that would somehow resolve itself. It would somehow resolve for the harms inherent to its existence. My opponent said in their last speech that they won't wipe out the state, so they will not solve for biopower, which is a characteristic of modern statehood, as Foucault says. They say this their K gives ground. What ground? How does a K which specifically says the terms of debate are unjust give the AF ground? They conceded our answer to topicality, so we can consider that we met their interpretation. Finally, you should extend you should vote AF and extend a number of our previous arguments. Vote AF to reduce limits on immigrants escaping emotional and physical abuse, which is cyclical in nature and locked in system oppressions that are being felt by these women materially now that our AF can solve for. Extend USCIS 2020 that existing caps have created barrier. Extend both solvency cards. Extend the advantage that is all the Regime et al. 2019 evidence that Latinos are uniquely affected by horrific violence, and then the plan solves by improving emotional well-being, economic stability, and creates hope for the future. And finally, extend our framework. Our framework gives voice to battered women that are more proximal and probable impact than the outweighing of the abstract notion of biopower, which our opponent's alt doesn't even address meaningfully, given that they've specified the actor for the alt is the state, the very thing doing the harm. You should vote AF because their K is a violation of the rules of NFL debate. Their K doesn't make sense, and our AF case is still intact.
So yeah, I'm pretty sure that the little instruction said that we should not disclose, and you'll find out the final result at the award ceremony.
Okay, thank you all for judging, and thank you to my opponent for being here today.
Thank you so much. Yeah, good job today. Thank you, guys.
You're welcome. Bye.